Good afternoon, everyone. I notice it's straight up 12 o'clock and there's still some folks joining us. But meanwhile, as more people trickle in, I will introduce myself. My name is Lisa Carlson, and for those of you I haven't had the pleasure of working with yet, I'm a healthcare attorney at Holland & Hart. I've been here for about a year, and before I started at Holland & Hart, I was in-house at a large health system. So today I'm going to be going over the key legislation that will impact healthcare providers that was enacted during the last legislative session. And I don't know about many of you, but while many of these pieces of legislation were being considered and passed, I was a little bit preoccupied with coronavirus, as many of us still are. And so I wasn't following the legislation as closely as I typically do. So I figured this might be helpful for those of you who were and continue to be preoccupied with responding to COVID. But a few items of housekeeping before we get started. Because this webinar is recorded, if any of you have questions, you can use the chat feature or the Q&A feature in WebEx to ask any questions that you may have. And then at the end of the webinar, I can follow up with each of you individually to hopefully answer any questions that you may have. All right, so let's go ahead and get started. So today I'm going to be talking about these pieces of legislation. So these were the major laws that will impact healthcare providers in Idaho. There's a few others that are not included on this list, and I've included them in a slide at the end of the presentation, and I'll touch on them briefly, but they were mainly smaller changes, so didn't really warrant a lot of attention. So I am going to get started talking about the Idaho Patient Act. So the Idaho Patient Act is also known as the Melaleuca legislation, was one of the more publicized pieces of healthcare legislation this session. It was dubbed the Melaleuca Law because Frank Vandersloot, who's the founder and CEO of Melaleuca, got behind the legislation after a Melaleuca employee's unpaid medical bill of, I think it was about just under $300, ended up leading to a request of almost $5,600 in attorney's fees. So this led to an entire movement to combat what they dubbed unfair collection action related to healthcare billing. And they created a website that had a compilation of patient stories of unfair collection practices. And the proponents of the bill insisted that the medical collection practices lacked transparency and often resulted in the imposition of unreasonable costs and fees, including attorney's fees, as I mentioned earlier. Opponents, on the other hand, generally healthcare providers, were and are concerned that it adds another layer of regulation onto an overly regulated industry. Because ultimately, the law applies to healthcare providers and healthcare facilities. So what it does is it requires that healthcare providers or facilities take specific steps in order to preserve the right to take what is dubbed and defined extraordinary collection action. So an extraordinary collection action is defined by the statute as either selling a debt to a third party before the patient has been in receipt of a final statement, which is also a defined term, for 60 days. So obviously you have to give the patient a receipt of what they owe, and they have to have adequate time in order to respond to that receipt or that statement. An extraordinary collection action also includes reporting any adverse information to a credit agency, and it includes recommending or commencing rather any judicial or legal action, including placing a lien, attaching or seizing property or accounts, initiating a civil action, or garnishing wages. So again, you have to take specific steps before you can commence one of those extraordinary collection actions. Now, the mandatory steps include you first have to submit charges to the insurance within 45 days of the provision of those items or services. And in situations where the patient does not have insurance, you would have to submit those charges to the patient directly. The second step is that the patient must receive a consolidated summary of services within 60 days. And again, a consolidated summary of services is a defined term, and it basically is like an itemization of what items the patient received. Now, it's important to note that the patient must receive that consolidated summary. So the timing is based upon a receipt standard. And so even though it says provide that summary of services within 60 days, the patient has to receive it within 60 days. And receipt is calculated based on the date it's mailed. So it's 3 days after the date that summary is mailed. So really, you have to provide a summary of services within 63 days. The patient must also receive a final statement from the billing entity or healthcare provider. So that final statement is going to be the equivalent of your itemized billing. So therefore, I call attention to that 60-day notice because if you're setting up your billing cycles, you'll need to, instead of operating on a 60-day cycle, you need to operate on a 63-day cycle. And the other element is, or I guess the third mandatory step is that you can't charge any interest, fees, or other charges until at least 60 days after the patient receives that final statement. So again, 63 days after you send it. And you cannot commence any collection action for 90 days after the patient receives the final statement. So again, 93 days after you mail it. The good news is that if you comply with all of those provisions, you can commence legal action and recover both costs and fees associated with the outstanding bill. But the bad news is that the costs and fees are limited to statutory caps. So for example, in an uncontested case, the fees would be capped at $350. And in a contested case, the fees are capped at $750. So again, if the patient doesn't fight it, then it's $350. If the patient does fight it, it's $750 is the maximum fees. If a provider does not comply with the statutory framework, there is a little bit of leniency allowed, meaning the provider can sue to collect the fees, but you can actually sue and commence that extraordinary collection action, but you cannot collect any costs and fees associated with that collection action. Where a party commences that extraordinary collection action without adhering to the statute, the patient can recover actual damages and or $1,000, whichever is more. So there's a fine involved for those healthcare providers that commence that extraordinary action or extraordinary collection action without complying with the statutory framework. Additionally, there's no statutory cap on fees that patients can recover if they prevail against you who's trying to collect against them. So it's really important, obviously, to adhere to the statutory framework. Other elements that are more nuanced is that the person seeking to engage in extraordinary collection action bears the burden of establishing that the statutory requirements have been met. That means documentation is going to be really important to ensure that you can show that you gave that, you mailed the statement on this day and you waited 63 days before you commenced any type of subsequent action. The other thing is you want to make sure that you have updated patient addresses so that when you're mailing those statements, that it's going to the correct address. I think there's another element to this that isn't contemplated within the statute, but that could be impactful to healthcare providers, and that's this legislation may influence collection agencies' willingness to take on medical debt collection responsibilities, primarily due to the implications of profitability. It just may not be profitable enough to pay attorneys fees to commence these actions to collect unpaid medical debt when there's a statutory cap on fees. So that's all I will say about the Idaho Patient Act, but again, feel free. I know it's very complex. It was long, and so if you have any more nuanced questions, please feel free to send those along. And of course, I didn't advance my slide while I was talking, but that's okay. It's all in the slides, and you guys hopefully have copies of those as well. Okay, so the next law that I'm going to talk about is Simon's Law. So Idaho is the 5th state to enact this particular legislation, joining Arizona, Kansas, Missouri, and South Dakota. This law was created after a tragic medical situation involving a 3-month-old named Simon. Simon had trisomy 18 and spent his life in the hospital. And on one particular occasion, his oxygen levels dropped and staff made no effort to save his life. And when the parents probed and questioned, they realized that a DNR had been placed in his chart without their knowledge. And so staff were acting pursuant to that do not resuscitate order. So they engaged in this effort to prevent this from happening to any other parents. So ultimately, this law constrains when a provider can write an order withholding life-sustaining treatment from an unemancipated minor. So the first thing to note about this law is that it defines unemancipated minor very narrowly and not necessarily consistent with other provisions in Idaho law that define what an unemancipated minor is. So this law defines an unemancipated minor as not married and not in active military service. But other laws consider an unemancipated minor or emancipated minor to be emancipated by order of the court, or if they've been married and divorced, they're emancipated, or if they're self-supporting. So that's one example of an inconsistency that you need to be aware of, that unemancipated minor is very narrow here. It includes the order not to resuscitate, an order to withhold artificial life-sustaining procedures, or orders to withhold artificial nutrition and hydration. Those are all included within the scope of this law. And what it does is it requires notification, both orally and in writing, to at least one parent or guardian. And in making that notification, you have to make diligent notification efforts for at least 72 hours. And then you also must make reasonable efforts to inform the other parent. When making the diligent notification efforts and the reasonable notification efforts, it's critical that you document the efforts that are being taken, when they're being taken, and who's making those efforts. That's a critical component of the statute, and also to have any defensibility here. There's also, with this law, a waiting period of at least 48 hours from the time that you are able to notify a parent or legal guardian. So once that parent is notified, that's when the clock starts to, that first parent, that's when the clock starts to run for the 48 hours. Within that 48 hours, the parent or guardian will have the opportunity to request a transfer to another facility or discharge. So the purpose of this statute is if a facility thinks that life-sustaining measures are futile, and that can be, concerning for staff when they're trying to sustain somebody who is whose life is unlikely to be sustained without these alternative measures or external measures. But it doesn't require the hospital to keep providing those indefinitely. It says you have to give the parents notice and opportunity to transfer or to discharge somewhere else to get care elsewhere for somebody who's willing to, keep that child alive. So with the transfer, the hospital must continue to provide that artificial life-sustaining procedure for a minimum of 15 days after a parent requests a transfer. And the hospital must also make every reasonable effort to assist the parent in the transfer process. If after the end of those 15 days, again, the 15 days starts running from the time the parent makes the transfer request, then the provider at that point in time can institute a DNR order. So again, this law is interesting in that it's somewhat imprecise and doesn't fit well with existing Idaho law. I gave the example of the unemancipated minor definition, but there's also some inconsistency with the Medical Consent and Natural Death Act. The statute specifically says that it is supposed to be consistent with those provisions, but those provisions, specifically the ones that are called out in the statute, allow one parent or guardian to deny or withdraw care. So here you have to notify both. So it doesn't help or solve the question of what happens once you've notified both parents or guardians and they don't agree on the appropriate course of action for the minor. So does this law require both parents to consent? And that's still an open question. It's not answered in this law. Okay, so, and also I'll note at the bottom, most of these laws are effective starting July 1st, so it's coming up here shortly. I will note that, back up in my slide, the Idaho Patient Act is not effective until January 1st, 2021. So providers have some time to modify any billing practices, billing software in order to make sure they're in compliance before the new year. So I will call out any others that are specifically going into effect other than July 1st. Okay, so the next law is regarding pharmacy benefit managers. So this legislation helps regulate pharmacy benefit managers, which are companies that manage prescription drug benefits. They do this by negotiating with drug manufacturers and pharmacies to control drug spending. So PBMs, as I'm going to call them because it's less of a mouthful, they significantly impact drug costs for insurers. They impact patient access to medications, and they determine how much pharmacies are paid. So the purpose of this legislation is really to increase transparency around PBM activities. First, they're going to be required to register with the Department of Insurance by April 1st of each year before anyone can perform, offer, or advertise any PBM services. Second, the law prohibits the inclusion of gag clauses in contracts. These gag clauses typically were preventing pharmacists from being able to inform patients on how they could spend less on prescriptions, or these contracts may have had penalty clauses if pharmacists recommended a cheaper brand alternative. So no more gag clauses in contracts. Third, for PBMs that use maximal allowable cost pricing, it imposes a host of requirements to increase the transparency there. The maximum allowable costs are the prices at which the PBMs reimburse pharmacies. So under this legislation, the PBMs have to provide to any network pharmacies the sources that they use to determine the maximum allowable cost pricing for the cost list that they're using for that particular provider. And they also have to update any changes to the maximum allowable cost at least once a week. And then finally, this legislation prohibits PBMs from retroactively denying or reducing claims for reimbursement unless a specific exception exists. Those exceptions are where the claim was submitted fraudulently or improperly, or if the PBM PBM's payment was incorrect because the pharmacy had already been paid. I anticipate that the Department of Insurance may issue additional regulations related to this statute, but so far I haven't seen anything. So the next one is telehealth. So telehealth is the talk of the town right now. It's really being advanced quickly with the coronavirus pandemic situation. Providers are relying on it significantly. There's a lot of talk at the national level about expanding access via telehealth through Medicare, expanding reimbursement, and even at the state level, Governor Little's most recent executive order, which was just issued on June 22nd, he specifically called out how the loosening of healthcare advances seen during the pandemic have helped to increase telehealth, and his intent is to make some of these healthcare advances more permanent moving forward. So it'll be interesting to see if some of the flexibilities that we're seeing related to telehealth will continue moving forward. But meanwhile, I will focus just on the new legislation that was passed with respect to how that will impact telehealth. So telehealth, this particular legislation broadens what types of services are encompassed by the definition of telehealth services. So it specifically calls out that it includes assessment, diagnosis, consultation, treatment, remote patient monitoring, transfer of medical data, education, public health services, and health administration. And it also specifically excludes certain types of services that are not telehealth, and those are telephone calls where the provider doesn't have access to patient records, non-HIPAA compliant email and fax, and then faxes. So those would not constitute telehealth. The other thing that this legislation did is it amended how providers can establish a provider-patient relationship. So previously, if a provider did not have an established treatment relationship with a patient, they had to establish that relationship via two-way audio and visual interaction. Now, providers can establish that new relationship by use of two-way audio only. So there's that elimination of the video component requirement. It's important to note that HIPAA security rule requirements will still apply regardless of what platform is being used. This confirms that telehealth can be rendered anywhere the patient is located, including the patient's home. But of course, it's important to note that providers are still required to comply with telehealth laws wherever the patient is located. So this is going to be specific to providers that are providing telehealth services to patients that are located in Idaho. So other state laws will apply if a patient is located outside of Idaho. And that is all I have to say about telehealth. But again, reach out if you have any questions, especially if you have questions about the current flexibilities with telehealth, because there certainly are a few of those on both the local and national level. Okay, so the next one is the healthcare provider immunity. So this legislation expands existing laws to protect certain types of healthcare providers from liability, particularly when they volunteer to provide free medical care. The coverage will now expand to counselors, social workers, psychologists, physical therapists, pharmacies, and dietitians. So expands who is covered. And it also includes students. So as long as a student is being supervised by someone who is present in the facility while they provide care, the immunity under this statute will extend to students as well. And again, as long as they're acting within their scope, and then there's an additional element that the patient must notify the individual that they are a student. This one is helpful. The intent of this is to encourage volunteerism throughout the community at free medical events and community health screenings. And the way to do that is to allow providers to have a little bit more immunity and protection from claims. Okay, the next law is an abortion law. This one is a trigger law. So a trigger law is one that becomes effective in the event of if a certain circumstance happens or comes to fruition. And so here the trigger is if Roe v. Wade is overturned by the Supreme Court of the United States, which is the SCOTUS, then this legislation will go into effect 30 days after the overturning of Roe v. Wade. And also, the other triggering event is if there's an amendment to the United States Constitution permitting states to govern abortion at the state level. At least 9 other states have these types of trigger laws. And I'm not going to spend too much time on it just because it's not in effect yet. As you can see at the bottom, it's a to be determined. And I don't have any forecast as to whether the Supreme Court has any intention of overturning Roe v. Wade. That's a whole separate issue, so I'm not going to weigh in there. But what's important to know about this statute is that it does criminalize the performance or even the attempt to perform or the assistance in performing or the assistance in attempting to perform an abortion. So it will impact any person who performs that abortion criminally. It's a felony punishable by no less than 2 years in prison or a max of 5 years. And then the professional license will be impacted by anybody who is either performing or assisting in performing. It requires a 6-month minimum professional license action suspension for the first attempt and then a permanent revocation for the subsequent offense. There are affirmative defenses available under this law for situations where a physician would make a good faith medical determination that the abortion is necessary to prevent the death of the pregnant woman. However, the physician in those circumstances must first attempt to perform the abortion in a way that provides the highest survival chances for the unborn child. Similarly, if a woman, if it's not about the health or safety of the woman, if a woman reports rape or incest, it requires a report be made to law enforcement agency, and that a copy of that report be provided to the physician. And that's true for minors as well. Under this law, pregnant women are expressly excluded from any criminal conviction or penalty. Okay, so the next law is the drug history review. So this legislation arises out of our state's efforts to combat the opioid crisis. So the PDMP is the Prescription Drug Monitoring Program. And in this program, prescribers are required to register to maintain a controlled substance registration. But previously, or I guess currently up until July 1st, they are not required to check the system. So in reviewing how frequently providers are checking the PDMP before writing a script, it showed that of the top 100 prescribers, on average, they're checking the system only 37% of the time for potential for drug abuse issues. And this number has been consistent for the last 2 years. So this new law will require anyone who's registered with the PDMP to check a patient's drug history for the last 12 months before they issue a prescription for outpatient use of opioids or benzodiazepines. There are exceptions available. These exceptions are situations where a patient is receiving inpatient care, where drugs are being administered at the scene of an emergency or in an ambulance, hospice care, skilled nursing facilities, and then outpatient prescriptions that last no more than 3 days. And again, this law will be effective July 1st. The next one is Medicaid reimbursement. So there were some changes to reimbursement methodologies that Medicaid passed, and these went into effect actually on March 3rd of this year. So these have been in effect for a while. So likely if you had any questions, you may not have them anymore. They may have been answered. But the purpose of this legislation was to reduce net reimbursements to hospitals and nursing facilities in order to accomplish reductions in the Medicaid spending needs. And the goal is to reduce 1% for state fiscal year 2020 and reduce by 2% for state fiscal year 2020. So it accomplishes these reductions by changing reimbursement rates for specific facility types. For hospitals, it involves replacing cost-based reimbursement methods with value-based methods, and also establishing a quality payment program. And then for nursing facilities, it requires the department to work with the facilities to establish a new prospective payment method to replace existing reimbursement methods. The new payment method must take into consideration patient needs, quality of care, reasonable cost principles, and state budget limitations. And the intended effective date of the new payment methodology for nursing facilities is July 1st, 2021. So they have some time to work collaboratively with facilities to come up with a plan going forward. It's estimated that the cuts resulting from this legislation will reduce the general fund needs by approximately $4.9 million in 2020 and $13.7 million in 2021. Okay, so the next one is nursing home administrators. This isn't a major change, but it does modify previous language that allowed individuals to qualify for licensure without the 1,000-hour supervision and examination requirement, as long as they meet some specific educational requirements. So now someone with a master's degree in health administration that's related to long-term care that without any management experience, or someone with a master's degree with emphasis on healthcare with 1 year of management experience in a facility providing inpatient care will be able to qualify for that nursing home administrator license. So again, not a major change, but helpful if you have a lot of education and want to be able to use that to expedite the licensing process. Okay, so advanced practice RNs. So APRNs have been able to practice without direct supervision of a physician since 2004. And this law was introduced because there's a number of statutes that still are on the books that require a physician signature. Some examples of those are jury exemptions, parking permits, mental health declarations, athletic physicals. And this law tries, it allows an APRN to fulfill the requirement of a physician signature. So they don't have to change all of those existing laws. This law just circumvents or supersedes those other requirements, saying that a physician signature can be fulfilled through the signature of an APRN. And an APRN includes a certified nurse practitioner, certified nurse midwife, certified registered nurse anesthetist, and a clinical nurse specialist. It is important to note that it only applies in situations where it's a law that requires a physician's signature or affirmation. So there may be circumstances where a private party or a third-party payer may still require a physician's signature, and those would still be applicable unless the third party amended their requirements. Okay, hospitals, IDAPA, and conditions of participation. So last year, when the hospital IDAPA regulations were significantly overhauled, it created a few discrepancies between state-level regulations and the regulations that are imposed upon Medicare participating hospitals through the conditions of participation. Some of these included issues of informed consent, for one example. This law effectively provides that where a state law is more restrictive than a federal condition of participation, the federal condition of participation will govern. But again, it only applies to CMS certified hospitals. So if there's a hospital that is not certified under CMS, then the more restrictive state standards would still apply. There's also some question outstanding as to if there is no condition of participation at the federal level, the likely outcome is that the state restrictive standard would apply in those circumstances. So it's really only impactful where a federal condition of participation exists and is less restrictive. Okay, the next one is the overhaul to the willful or reckless misconduct standard. So Idaho has a $250,000 cap on non-economic damages, and it generally does not apply to conduct that constitutes a felony or actions arising out of willful or reckless misconduct. But the term willful or reckless misconduct was never defined, and a case recently before the Idaho Supreme Court brought that to the court's attention, and they identified there's no definition. So the legislature sought to remedy the absence of definition, and now there is a definition for willful or reckless misconduct, and that is conduct in which a person makes a conscious choice as to the person's course of conduct under circumstances in which the person knows or should know that such conduct both creates an unreasonable risk of harm to another and involves a high probability that such harm will actually result. Now, the intent of this is to ensure consistent application of Idaho liability laws. Okay. And then finally, the other changes. Now, I mentioned these are all more insignificant changes, but I'll go over high level what these changes were really quickly. So the controlled substances legislation adds additional controlled substances to mirror the DEA scheduling decisions for 2019. So if you look at that bill, you'll see a host of new substances, very long names of substances. The Pharmacy Act, it had minor updates, addresses forfeitures and addresses some discipline concerns, but otherwise it's mainly just housekeeping and updating that act. The Certified Medication Assistance legislation, it repeals the existing statute and adds an entirely new statute in an attempt to clarify the previous rules, which were confusing regarding requirements on how to become a certified medication assistant. It also provides an avenue for CNAs or certified nursing assistants to get additional training to be certified to administer medications. Chiropractor prescriptions. This one allows chiropractors that are certified in clinical nutrition to obtain patient-specific prescriptions for office use from a licensed Idaho compounding pharmacy in addition to an outsourcing facility, which was previously allowed. And then the Advanced Directive Registry. Currently, the Healthcare Directive Registry is managed by the Secretary of State. And this legislation actually shifts responsibilities to the Department of Health and Welfare, and it imposes a requirement that the registry be available 24/7. And notable bills opposed. I included this just for information. Not going to talk about these bills a lot, but something to note. Obviously, when a bill gets a lot of press or it is advanced even for the first time, there's a likelihood that it may be modified and then advanced again in the future. So I include these so that you can look at the bills and see if there's anything that may be of interest to you, to understand maybe why it wasn't passed or why it didn't make any traction in committee. Some of these are for optometrists, the transgender medical care balance billing, which is at a national level being addressed by many states and is likely to return. Adolescent treatment programs, discrimination of unvaccinated persons, and then battery on healthcare workers statute. That one was just passed not too long ago, and so they're seeking some amendments contemplating exceptions for mental health situations. But with that, that is all of the laws that I was going to talk about today. So again, if you have any questions, please feel free to either email me, you can call me directly, or if you've chatted or done a Q&A, then I will respond to you offline. Otherwise, I hope everyone has a wonderful afternoon, and thanks for joining.